Stuart Andrews is a partner at the law firm of Nelson, Mullins, Riley, and Scarborough in Columbia, South Carolina. He's the head of his firm's South Carolina Healthcare Group and former chairperson of the firm's pro bono program. He serves on a number of statewide task force on healthcare policy in South Carolina, and among his previous posts, he was executive director of the South Carolina Legal Services Association, chairman of the South Carolina Legal Services, chairman of the South Carolina State Board of Education. He received his bachelor's degree from Erskine College, his JD from the University of South Carolina School of Law. Senator Graham asked that he be part of this panel, and I'm more than happy that you've joined us today. Mr. Andrews, please proceed.
Thank you, Mr. Chairman. Thank you particularly for your interest in the subject of enormous significance to men and women incarcerated in our prisons and jails throughout our nation. I'm grateful for the opportunity to provide the committee with information concerning the use of solitary confinement in South Carolina prisons, particularly the use to which inmates diagnosed with mental illness have been subjected. The Nelson Mullins Law Firm represents a class of inmates with serious mental illness in South Carolina prisons, many of whom have spent significant time in solitary confinement. I am appearing today on behalf of that class and its guardian ad litem, Joy C.J., as well as on behalf of Protection and Advocacy for People with Disabilities, a South Carolina nonprofit organization charged by federal and state law to protect and advocate for the right of people with disabilities. After years of investigations, reports, and negotiations, the inmate class and P&A filed suit in South Carolina State Court in June 2005 against the South Carolina Department of Corrections, alleging violations of the South Carolina Constitution's prohibition against cruel and unusual punishment, and seeking injunctive relief to require the provision of adequate mental health services to our class inmates. After more than 6 years of litigation, a bench trial was held in March and February of this past year, although no ruling has been entered to date. A major issue in the trial was the extensive reliance by the Department of Corrections on solitary confinement as a means of managing inmate conduct, particularly inmates with mental illness. During their imprisonment, nearly half of the 3,000 men and women with mental illnesses on the department's caseload have been held in solitary confinement for periods cumulatively averaging almost 2 years. The effects of the conditions in solitary confinement can be harmful for anyone, but they particularly expose individuals with mental illness to substantial risks of future serious harm. The applicable Eighth Amendment standard applied in systemic conditions cases like ours. To illustrate some of what we've learned about the operation of solitary confinement in our state's prisons, I would like to call your attention to two individuals who've been members of our class. The first is Theodore Robinson, who is a 50-year-old man with paranoid schizophrenia serving a life sentence. Mr. Robinson's speech is highly disorganized, and he has a history of bizarre behavior, such as drinking his own urine. Like many people with schizophrenia, he suffers hallucinations and delusions. For example, he believes that at night, while he sleeps, doctors secretly enter his cell and perform surgery on him. From 1993 through 2005, a period of 12 consecutive years, Mr. Robinson was kept in solitary confinement. 15 days after our lawsuit was filed, however, the department removed Mr. Robinson from solitary and placed him in its psychiatric residential program. Other inmates with serious mental illness have not been so lucky. In South Carolina, mentally ill inmates are twice as likely as those without it to be in solitary confinement. 2.5 times as likely to receive a sentence in solitary that exceeds their projected release date from prison, and over 3 times as likely to be assigned to an indefinite period of time in solitary. Mentally ill inmates placed in solitary are not limited to those with mild mental disorders. Like Theodore Robinson, many are diagnosed with schizophrenia or other serious mental illnesses such as bipolar disorder, schizoaffective disorder, or major depression. A Department of Corrections psychiatrist at Lee Correctional Institute, for example, estimated that 40 to 50% of her caseload who were in solitary confinement were actively psychotic. Perhaps the single most deplorable solitary confinement unit in the South Carolina prison system is a cell block in Lee Correctional Institution known as Lee Supermax. On February 18th, 2008, an inmate named Jerome Laudman was found in a Lee Supermax cell, laying naked without a blanket or mattress, face down on a concrete floor in his own vomit and feces. He died later that day in a nearby hospital. The cause of death was reported as a heart attack, but hospital records noted hypothermia, with a body temperature upon arrival at the hospital of only 80.6 degrees. Mr. Waldman suffered from schizophrenia, mental retardation, and a speech impediment. According to his mental health counselor, he had never acted in an aggressive or threatening manner. On February 7, 2008, 11 days before his death, Mr. Waldman was moved to Lee Supermax, purportedly for hygiene reasons because he refused to take a shower, although no one later admitted to ordering the move. On February 11th, 1 week before Mr. Waldman's death, a correctional officer saw him stooped over like he was real sick or weak. The officer noticed styrofoam trays piled up inside his door that had not been collected. He considered notifying a unit captain or administrator, but was discouraged by his supervisor. On the afternoon of Mr. Waldman's death, 2 nurses were called to Mr. Waldman's cell. They observed him lying face down in his own waste and vomit, but still alive. The styrofoam trays were still there with rotted food. The conditions were so foul that the nurses and the correctional officers whom they summoned refused to enter the cell to remove Mr. Waldman, who was still alive at that point. So instead, they called 2 inmate hospice workers who took 30 minutes to get there, at which point they removed the body. And later that day in a hospital, Mr. Waldman died. In South Carolina, a disproportionate number of mentally ill inmates are placed in solitary confinement. Many are actively psychotic. Conditions are atrocious. Mental health services inadequate. Stays are inhumanely long. Theodore Robinson was fortunate. After 12 consecutive years in solitary, he was transferred to a psychiatric residential program, but coincidentally, 2 weeks after he filed a lawsuit against the department. Jerome Waldman was not so fortunate. After 11 days in Lee Supermax, he died of neglect and in a cold, filthy cell. For other inmates with mental illness and solitary confinement in South Carolina, the story is ongoing. Will they receive adequate mental health treatment to stabilize their mental illness? How well will the solitary prepare them to handle the transition back into the community? These questions and their implications for the constitutional rights of all mentally ill inmates in South Carolina remain unanswered today, and we thank you in this committee for undertaking them to try to improve and correct them. Thank you.
Thank you for your testimony. I think your dedication as an attorney in private practice really is an indication of why they call it a profession and not just a job.
Thank you, sir.
Thank you.
As Chairman Durbin mentioned in his opening remarks, America incarcerates more people per capita than any of the world's democracy. We have 5% of the world's population and yet 25% of the world's inmates. And I think we need to take a really hard look at our criminal justice system. I thank you, Commissioner Epps, for your work. And we need to make serious reforms, and that's why I support the Criminal Justice Commission Act, which Senator Webb has been working on for years now. And the bill would convene a commission of experts to make policy recommendations that would help make the criminal justice fairer and less costly. Do each of you agree with this top to bottom review of the criminal justice system, or that it would be useful? And what issues should that commission consider in making its recommendations? This is wide open to anyone.
Senator, if I may, while it's certainly critical to examine the entire system, it would be a mistake, in my view, if the analysis were limited to the criminal justice system. I think as everyone in this room is aware, that particularly with regard to inmates with mental illness, that the increase in the number of individuals with mental illness who've been incarcerated directly correlates to the decision by the state and federal government to deinstitutionalize and to reduce funding for programs for the mentally ill throughout the country. And that occurred. It's directly related to the increase in the incarceration rates. And to the degree that this committee's work is done in isolation from community-based mental health services, it will be missing a large part of the remedy, in our view.
I'm in total agreement with that, and we've had testimony about, the criminal justice system being a substitute for a real mental health policy in our society. One of the federal solutions to this problem is the Mentally Ill Offender Treatment and Crime Reduction Act, or MIOTCRA, which provides courts, police, and prisons the resources they need to address the special needs of people with mental health problems. But that bill is scheduled to expire next year unless Congress acts. Do you all agree that this law should be extended? And what recommendations do you have for Congress as we revisit that law? In other words, what recommendations do you have to address the incarceration of people with mental health problems?
Well, I would like to address the issue concerning the failure of any independent review or right to access to counsel by these individuals. From the public defender's point of view throughout the state systems, there is an underfunding of those positions. While all states, including South Carolina, are attempting to address that, the recent economic problems and the budgetary limitations have imposed greater stresses on those systems, which would make it difficult for individuals to properly raise the mental illness issues that directly relate to the crimes for which they are charged. There's a secondary issue that has been raised by your previous questions related to the three particular recommendations that you asked of Commissioner Samuels, and that has to do with the due process that's available for inmates, particularly with mental illness, to be able to challenge determinations concerning solitary confinement. Without the capability of providing an independent ombudsman and independent counsel for those individuals, it's a system just reviewing itself, and it's the fox guarding the henhouse in a way that repeatedly, in hundreds of cases that we examined, rarely, if ever, results in any true due process or fairness for the inmates themselves.
Yeah, you talk about having an independent psychiatrist.
Independent psychiatrist, counselor, and evaluation. That's right. And frankly, the access to counsel who can represent the interests of these individuals who are rarely in a position of ever effectively representing themselves.
Sure. Thank you, Mr. Chairman.
Thank you, Senator Franken.